to include any more details, but we do know that the scheduled hearing is still set to take place on the 31st in about a week and a half in Carroll County. And by then, Richard Allen should have newly appointed public defenders.
And I know the judge did say a case of this magnitude, she doesn't necessarily expect that these newly appointed public defenders are going to be ready for trial in January, because she recognizes it is a big case with a lot of discovery and other things they're going to have to do to be prepared. Matt Johnson, always great to have you on. Thank you for your excellent reporting there live in Indiana. I want to bring in our guest for this hour, trial attorney Kelly Hyman. All right, Kelly, what's your initial reaction as we're watching this together?
A client can always fire the attorney. That is their right. I'm trying to understand what exactly happened. I don't have privy to the documentation that was filed, but also the attorney has to be very careful in what they say in their motion to withdraw, because they need to protect the attorney-client privilege. That is communications between the attorney and the client. Now, it appears that potentially there might be some financial issues, and that's the reason why. However, we'll have to, might not know ultimately what happened in this, but the judge can make the final determination, which the judge did, to grant the motion. And sometimes the judge could potentially deny it, and that means the attorneys would have to stay on the case. But it appears that it might be some kind of financial issue.
I agree with you, Kelly. Two things stood out to me. First of all, the judge represented that she understood the financial situation of Richard Allen remained static, and that she would therefore appoint public defenders. So to me, that says he doesn't necessarily have the ability to pay the current attorneys. But the second is she noted it was an oral motion and that they will follow up with filing. And to me, that means this was a new development, because as attorneys in trial, you know as well as I do, Kelly, and as a judge, this happened to me all the time. Last minute, sudden things had to be argued orally and then follow up with the motions and the things in writing that would then be filed. So what does that say to you, if anything?
That they were trying to protect the privilege, or it's something that came up right away. And so that could possibly happen. Attorneys have certain ethical obligations that they have to do as well. And so it seems understandable why they wanted to do it orally, because they still have an obligation to their client to protect the attorney-client privilege, but they still, if they need to withdraw, have to let the court know what exactly their basis is and the reason for withdrawing potentially. But you still want to protect that attorney-client privilege, and sometimes you're not allowed to exactly say that and have to leave it up to the court that you can't go forward. And this time is crucial time, because the case was about to go to trial.
Yeah, and here's the other thing I like about this judge, and certainly appreciate, she gets it. She says, okay, clearly he can't go forward today without an attorney, so this hearing's continued to October 31st. But then, as I just discussed with Matt, she also said, given the magnitude of this case, they may not be prepared to go to trial in January. And every once in a while, you see a judge who takes a hardline approach, which is, this is when the trial is, you better be ready. So I think she is really handling this beautifully in terms of, we may have to pivot. This is just where we are. We're appointing counsel. And important to note, Kelly, your thoughts on this? The current attorney said, obviously, they'll hand everything over and cooperate with the new attorneys so those new attorneys can get up to speed.
That is key, to cooperate and to provide. The judge also stated about the work product privilege, and that they have certain documents that they can't exactly turn over. But Judge, you make a really good point, because the other counsel that comes in needs time to go through the case and develop this case, and potentially there might be people that they need to talk to and interview with and get up to speed. And so it's really important, in order to have an adequate defense, that the attorneys need time and the defendant needs time as well in this case. And that is very admirable of the judge, of understanding that the person needs a significant amount of time to get up to speed.
Yeah, I agree with you, Kelly. All right, I like this judge so far. We're going to see what happens on October 31st. That's the next court date in Indiana against Richard Allen. All right, we need to take a break. Coming up, we'll get back to testimony in the Take Care of Maya trial. You're watching Court TV, your front row seat to justice.
Tell us where the kids are.
This mother of two missing children just didn't seem to care.
I mourn with all of you who mourn. victim to verdict. All new Sunday night, 8/7 Central, only on Court TV.
Tonight on Closing Arguments, our cameras are inside the courtroom for today's important status hearing in the Delphi murder case. We'll take you live to Indiana for the very latest.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
I remember that my mom was on this phone call, and the person who she was speaking to, they claimed that I never asked to speak to my mom. I was doing fine. I was okay in my room. I hadn't had any questions about why my parents weren't allowed to see me. And that infuriated me so much because all I did for days on end was demand to speak to my parents. That's all I wanted to do.
We are watching together the Take Care of Maya civil trial out of Florida. The Kowalski family is suing Johns Hopkins All Children's Hospital, alleging false reporting of child abuse and other claims. On the stand right now, it's a former nurse at Johns Hopkins testifying about her interactions with Maya's mother, Beata. Let's get you back to court.
Was there ever a time that you saw Mrs. Beata Kowalski request the anesthetic propofol?
Yes.
Okay, what is propofol?
Propofol is it's a sedation agent. It's used usually for procedures. It gives it's a deep sedation, and it's used in ICUs, it's used in ORs, we'll use it. Not really, sometimes in an ICU for procedures, for doing a procedure at the bedside, a significant procedure.
And what do you recall about this incident where Mrs. Kowalski was requesting propofol?
I don't remember all the specifics. I know that she wanted propofol. I don't know why. It's usually a sedating agent. And I remember thinking it's for sedation, and I don't know why Maya would be sedated, but she kept insisting she wanted propofol, and I thought that was unusual to have for propofol in that situation.
Were there ever times that you recalled Mrs. Beata Kowalski requesting sedative drugs around the time that Maya was about to go to sleep?
Yes.
Did that strike you as unusual?
Yes, and there was a couple.
Foundation predicate knowledge of that. Overruled.
You may answer.
So there was a couple times when Mrs. Kowalski wanted me to give Maya some pain medicine, and one time she said to me, she's like, one time Maya was almost asleep. Her eyes were drifting off. She was resting comfortably, and Mrs. Kowalski went to Maya to wake her up and said, "Maya, are you in pain?" And I thought, oh, you don't wake her up. She's sleeping. And that was one time that she did it. Another time she was saying, "She's in pain. She's in pain. You need to give her pain medicine." And normally, I will work with the parents 100%. I had been in ICU for a long time, pediatric ICU for a long time, and I work with the parents if they think that. But this time, this was different. She was saying, "She's in pain. She's in pain," and I really didn't want to get involved. I didn't want to answer because I just thought she was not in pain. And then Mrs. Kowalski said to me, "Don't you see she's in pain?" And then I thought, okay, she actually asked me then, and then I looked at Maya. Maya was completely calm. She was quiet. She was laying in bed comfortably. And then I looked up at the monitor, and I see she has the low resting heart rate. She had a low respiratory rate. And I said, "No, I don't see she's in pain." And that was unusual for me because, like I said, I don't want to be stingy. I treat pain very seriously. I especially treat children's pain very seriously. But it was obvious that Maya was comfortable, and I could tell not only was she resting, but you can see on the monitor her heart rate and her respiratory rate were low. And if I give her pain medicine, that can bring her respiratory rate down too low. And yeah, that struck me as very, very odd. I was nervous to even go ahead and do that, because if somebody's really in pain and their heart rate comes down from 150 to 120, that's okay. But if the heart rate is 70, 80, and now I'm bringing that heart rate down because of the pain medicine or the respiratory rate, now we're in trouble. So yeah, that kind of stuff was happening. And then, yeah, that was distinctive to me. That stuck out.
Nurse Clink, from your vantage point as a PICU nurse, were you concerned for Maya's care and well-being when she came into the hospital on October 7th?
Of course.
Thank you. Your witness.
All right, let's bring back in Kelly Hyman. That was the end of direct examination of that witness. Clearly, obviously, a defense witness being put up on the stand to defend the hospital and the hospital's actions. How did you find this former nurse did, specifically talking about she was really bothered by the mother waking up Maya to give her pain medication and really wanting to sedate Maya?
Yeah, she comes across as a strong witness for the defense, because now she's casting doubt in the fact that the mother had the best interest of the child and the fact that what she was doing wasn't actually correct. It'll be interesting to see what comes up on cross, because that's going to be key for the plaintiff to really poke holes at her testimony and maybe try and see if she has some kind of bias or some kind of motive, or go to her credibility, because she comes across as very believable and sympathetic as a witness for the defense. Very strong witness.
I agree with you. And cross-examination I really look forward to, because the reality is this jury's going to have to decide. Do they side with the mother and the mother's care for Maya, or are they going to side with the hospital saying mother wasn't doing what was in Maya's best interest? That's what this jury's going to have to decide at the end of the day. Kelly, stay with us. Still ahead, we're going to bring you more of this trial for Maya. Stay with us.
Tonight on Closing Arguments, 2 Indiana teenagers murdered, and now their alleged killer awaits trial. Our cameras are inside the courtroom for today's important status hearing in the Delphi murder case. What we learned today and what it all means for this high-profile case moving forward. Plus, previewing tomorrow's final pretrial hearing in the case against Charlie Adelson. What you need to know before this case gets underway.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Detectives and investigators have recovered what's believed to be human remains at Chad Daybell's residence.
You have 2 children who have vanished, and their mother doesn't seem to care about where her missing children are.
If somebody 2 years ago said this is what's going to happen with Lori,
I mourn with all of you who mourn.
I would have never believed it.
Victim to Verdict with Ted Rollins. All new Sunday night, 8/7 Central, only on Court TV.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Thank you so much for joining us. We want to get you back into court in the case Jack Kowalski versus Johns Hopkins All Children's Hospital. This is about Maya Kowalski, and they are alleging that this hospital did a number of different things, including intentional infliction of emotional distress in reporting child abuse and then keeping the child Maya, in the meantime, Beata, the mother, she took her own life. Let's get you back into court. Right now, a defense witness is on the stand about to begin cross-examination. As a former RN on direct, she was explaining why the mother's care of Maya concerned her. Let's go for cross.
Wow, with all that experience, you must have been really good at charting everything that was important, right?
I chart what I can get in there, yes.
And what's important, right? Mm-hmm. Really, if something astonishing happens, you're going to put it in there, right?
Nurses chart as much as they can get, as much as they can chart, as long as they're doing their patient care as well.
Well, why is it that, and I can approach and show the witness, from in all of your charting here over a few days, most of what you said about all the words and all the actions is never charted. Why is that?
Well, first of all, we do chart all the vital signs. We chart the meds. We chart what goes in the patient. We chart what comes out of the patient. Those are things that we for sure, we chart. We get in there from the medical point of view. The other stuff, if we can get some time to put the things that some of them are glaring. The incident with Dr. Teppa, where she called her that name and she said the whole words, the whole thing. I only gave the initials, but she said everything. The reason I didn't chart that is because most of our charting that we do for that is a communication tool in the hospital. Like I wanted, if we chart that the patient got out of bed, because when physical therapy comes, they will look at the child's chart and says, oh, okay, the kid was out of bed today. So something like that is what I would convey to the ICU team, specifically to the attending that's there. And Dr. Teppa was in the room. So this was during rounds. Everybody was there. Anybody that needed to know about what that kind of, those expletives, anyone was already there. There would be no reason for me to chart it. If I thought that I was going to be here where I am now, yeah, maybe I would have charted it. But Dr. Teppa knew. We all knew. I'm not going to. It's more, that kind of stuff is for the purposes of communication in the hospital. I didn't think I'd be here.
Anything else?
That's it.
On your explanation. Sir?
Yeah, I chart what I can chart. I mean, there's 12 and a half hours that we are there on the bedside. We are running. We're monitoring the patient. These kids are critically ill. We don't chart everything that's a communication that comes out like that. And like I said, the thing with Dr. Teppa, yeah, maybe I should have, in retrospect, if I knew I was going to be here, but at the time, anyone who needed to know was there.
Aren't you allowed to have either your phone or a cell phone from the floor on you as you make your rounds?
I believe we are, or we were.
Why is it, after 12 hours of all of this, there isn't a single photo or video or surveillance or anything else that confirms what you're saying?
Well, there's no cameras in the room. This happened in the patient's room, right? They don't have, unless they need to put it up for a specific reason, but there's cameras in the halls, and we're not allowed, I don't take pictures of any patients. We're not allowed to take pictures of the patients. I don't videotape the patients. I don't do that.
I see. So you nurses are not allowed to take pictures of the patients, right? Isn't that what you just testified to?
Yeah.
Okay. So I guess taking her into a room and stripping her down to her bra and her shorts and taking about 8 to 10 pictures of her, that would not be appropriate, would it?
Objection form, overall form, foundation. You can answer.
There are times when there are pictures taken, absolutely. They are taken for purposes, for medical purposes, 100%. And that's undeniable. But for me to just do it on my phone, to take a picture of the patient, I don't have any reason to do that. If it was a medical reason that somebody needed to do that, that does happen. That I know happens. People do that. I know different entities will do that. But as the nurses, no, I don't take a picture of a patient on my phone. Maybe unless somebody else has a reason to do that, possibly, but I don't. I'm answering for myself. What other people do is you'd have to ask them.
Anybody, anything else?
No.
You'd like to add? Okay. So if somebody were, say, to take a child and put them in a room and videotape them without their parents' consent or their consent, that would also be something that would be against your policies. Agreed?
I disagree.
So it's okay to videotape children without the parents' consent or anyone's consent but you, correct?
That's not what I said.
Well, if it's not the parents' consent and it's not consent from another authoritative source, that leaves you, right?
Sustained.
So, do you or do you not have the authority to do what I just described? Take a child into a room under false pretenses of an EEG and put her in that room, video her without her knowledge. Oh, put a commode just out of reach to see if you can tempt her to get over there. So, who gives the authority to do something like that?
Objection, argumentative, compound, foundation, sustained.
Are you, do you work with Kathy Beatty at all, ever?
I did in the past.
Not anymore.
Correct.
Not since you left, right?
Correct.
And before that, though, was she a PICU social worker?
Yes.
Were you a PICU nurse?
Yes.
So you saw her about every day, right?
No.
How often?
Maybe once a week, once every 2 weeks. And if she had a patient that involved me, we had the same patient at the same time, then I would. But if I had a patient that Kathy Beatty wasn't working with, then...
Okay. So with as stunning as all of this is, I mean, with a 10-year-old Kowalski throwing around words like this, you would have mentioned that to Kathy Beatty, right?
Objection, argumentative. Overruled.
You can answer.
No, not necessarily.
Well, wasn't she assigned to Maya and to move between floors with Maya?
I'm not sure what happened on the floor. I don't know if she was assigned on the floor. I don't have no knowledge of what happens on the floor. I don't know. I didn't recall. I don't recall telling her that. I don't recall. You mean when Maya was swearing?
Yeah, any of that stuff.
I don't recall telling Kathy. I don't know why I would tell Kathy. I would tell Kathy if there was a need for maybe some social services, but to go around and no, I didn't see her. I don't remember seeing her to do it. Maybe if something came up in conversation, but I don't recall telling Kathy Beatty. And like I said, the people, the people that were there knew, and that was kind of it. I didn't start telling everybody what happened.
How many nurses and social workers worked in that PICU at that time? We're talking about the fall of 2016.
Oh, I don't know, probably 40 nurses.
And there are nursing stations at different points, or just one nursing station?
There's different points. We're spread out.
Okay, on the floor, right?
Mm-hmm.
And so you're telling the jury, after all of this astonishing behavior, it did not spread to every single nurse and social worker on that floor?
Not only do I say I'm not surprised that it did not. It should not have spread to everybody on the floor.
Okay. So you don't think anybody else on the floor heard about it?
I didn't say that. You said everyone on the floor. No, I don't. The ICU is like a dumbbell. There's an area here, and then there's an area here, and then there's like a long hallway. This side doesn't really communicate. This is the east side, this is the west side, and then there's a few rooms down in the middle. No, we don't communicate. So the half of the unit is not going to hear what's going on in this unit, on this side. And no, there's a lot going on. People have a lot of their patients. They have these sick patients. Some kids are very sick.
Did you see that Clink's demeanor started to change as the witness? Why? Well, there was an argumentative objection that was sustained. Cross-examination's going after her. She doesn't seem to like it. How is that going to play to the jury? When we come back, we'll get you back in to more of this cross-examination.
Tonight on Closing Arguments, 2 Indiana teenagers murdered, and now their alleged killer awaits trial. Our cameras are inside the courtroom for today's important status hearing in the Delphi murder case. What we learned today and what it all means for this high-profile case moving forward. Plus, previewing tomorrow's final pretrial hearing in the case against Charlie Adelson. What you need to know before this case gets underway.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
I desperately missed my family. I wasn't allowed to really have any contact with them. So in this document, I'm expressing how much I miss them. I was extremely depressed.
Well, let's all go back together into the Take Care of Maya trial, continuing cross-examination of a former nurse, and we've hit the pause button so you haven't missed a thing.
Are on ventilators, some kids are dying, some kids are close to that, and yeah, maybe people over here would have heard it, but it doesn't mean that everybody there. No, and as a matter of fact, it's something that should not happen, that everybody goes and starts telling everybody what's going on in another patient's room. That's really frowned on, and we try not to do that.
Who did know? Say after your care conference.
I don't know. I think the people who knew in the room knew. There was a few of us. There was like the residents were there. I was there. I know there was the dietitian, because after she said that, we looked at each other and shocked. The whole room just went still. And then we moved on. It's an ICU. We moved on. And no, I don't think people told other people, a whole bunch of people, but everybody knew in that group, and Dr. Teppa heard it.
But no one out of that charted this afterwards. Okay, Dr. Teppa said something, but out of all those residents and everyone else in that room, no one else charted this in over 1,500 pages of medical records. Do you know why?
Yes.
Tell me why.
Because everybody, it's a need-to-know basis. ICUs with hospital, it's from our point of view, it's a need-to-know basis. If they didn't need to know, it didn't need to go in there. The doctor knew, I knew, the charge nurse, when I was charged that day. It didn't need to be told throughout the hospital and in the record. It's not something we would put in there. The things that we put in there, like I said, is more for communication back and forth, if the child ate this or whatever. And especially like in the beginning as well. Nobody knew that we would be here. And she most certainly said that. I mean, 100% she said that. But I wouldn't necessarily chart it. Not necessarily. There's no need for me to put that in there. Hindsight's 2020, and we look back and say, okay, now we're here. But at the time, nope, it was not something that would go in a chart.
Well, did you all tell risk management this, or was risk management already involved?
I don't know that. You would have to ask risk management. I don't know when risk management was called. I didn't call risk management.
Were you there when Ms. Teppa Sanchez called risk management?
I was not.
Did you talk to risk management at any point?
I don't believe so. I don't recall. I don't recall talking to risk management.
All right. So Ms. Winton came down, you never talked to her?
When who?
Isn't it? Yeah. Ms. Winton.
I don't recall that.
Okay. Somehow, though, risk management found out. Did it come to your attention? Let's see. All right. Well, you charted on numerous occasions that Maya was a 10 out of 10 on pain. Did you not?
I would have to see the charting and see what that was.
Do you remember any of the scores you gave for that?
Not offhand. I'd have to see it.
Okay. Well, I'm trying to find the actual number, but you did you did charge grimace, frown, withdrawn. That ring a bell. You did chart frequent chin quiver, clenched jaw, grimaces.
Your Honor, we'll object. We would appreciate it if the witness could see what Ms. Randerson's reading from.
If she wants it, I certainly will show it to her.
I do remember when I was doing the nursing admission assessment, and Mrs. Kowalski was at my side. And when we got to this part with the pain, Mrs. Kowalski is the one who told me, yes, that, and I remember that distinctly. So I don't know. So she told me when I first came in, like, we asked all the, the parents, but this time Mrs. Kowalski was next to me. Usually the parents are like on the couch or something, but, and I'll ask the parent, how does the child convey pain? Some kids will, bite on their blankie or whatever. So we ask the parents so that we know what to look for. And that's where that originated. So Mrs. Kowalski told me when she first came in, we were checking which boxes to check.
Do what?
Which one?
1001. Now, you've got, I believe, you've testified to about all of those. Is it your testimony now that Beata Kowalski told you to put all those down?
Well, Mrs. Kowalski told me when she first came in, when I asked how does Maya exhibit pain, and she went through each one and said, yes, this one, this one, this one, this one. And so then I continued on that that's how she exhibits pain. Yeah, I didn't see her frequent chin quiver, but I know Mrs. Kowalski's like, yes, this was affirm this. And so I did.
Okay.
I mean, I didn't say clenched jaw. She told me that that's how Maya has those recoveries.
All right. So now, you charted out, and if we can pull it up, 1001-1056, the nasogastric tube. Got it up? What's a nasogastric tube?
It's a feeding tube that goes into the nasogastral, so naso's the nose, goes into the nose, and then it drops down into the stomach. And
I have to question witness prep. Why? Because she goes on and on and on. Stop talking, answer the question, and be quiet. That's what she should be doing on cross. Stay tuned. Michael Ayala joining me next. I'm always happy for that as we continue Take Care of Maya trial coverage. Stay with us, Court TV, your front row seat to justice.
I remember that my mom was on this phone call, and the person who she was speaking to, they claimed that I never asked to speak to my mom. I was doing fine. I was okay in my room. I hadn't had any questions about why my parents weren't allowed to see me. And that infuriated me so much because all I did for days on end was demand to speak to my parents. That's all I wanted to do.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. We're bringing you testimony from the civil trial that was the focus of the Netflix documentary, Take Care of Maya.
The Kowalski's family is suing Johns Hopkins All Children's Hospital in Florida for hundreds of millions for alleged malpractice. Now, let's get back into the courtroom. We'd hit the pause button. The former nurse, Joanna Clink, is under cross-examination.
So then, what may have happened then is that when Mrs. Kowalski walked in, she was a nurse, right?
Correct.
You're a nurse, right?
Right.
Mrs. Kowalski was very dominant about what was best for her child, right?
Objection calls for speculation. Overruled.
Repeat that.
Mrs. Kowalski was very dominant about what she wanted for her child, right?
What she wanted for her child, yes.
Right. And she told you what she wanted for her child, right?
Mm-hmm.
She told you, a nurse, what she wanted for her child, right?
Yes.
But you didn't always agree, did you?
When Maya first came in...
I'm just asking you whether you agreed or didn't agree, ma'am.
Did I agree? What did I... Ask me the question again.
All right. At times, you disagreed with what Ms. Kowalski wanted to do, did you not?
Yes.
Okay. But she still insisted, right?
Yes.
And this was on the PICU floor?
Yes.
Mm-hmm. During the care conference, was Ms. Bagby there?
Who?
Nina Bagby?
I don't know who that is.
Do you recall the security people outside the door during your care conference?
I don't recall security outside the door.
You don't recall two security guys standing on either side of the door during that care conference?
Well, I was inside, so if they came after I was inside, I don't know, but I don't recall seeing that. No one told me the security's out there.
Actually, what happened was that Maya Kowalski was in extreme pain when she came in, wasn't she?
Mrs. Kowalski said that Maya was in extreme pain.
It was
yes, but you're asking me if I thought Maya was in extreme pain. There were times when Maya's heart rate was so low, she was resting, she was half asleep, and the mother was yelling, actually in my face one time, saying she's in pain, she's in pain.
Right.
And no, I did not think she was in pain. She was quiet, she was half asleep, and her vital signs were showing on the monitor. So Mrs. Kowalski may have believed, I don't know what she believed, but she said her Maya is in pain. And then she asked me, and she says, don't you see she's in pain? And I said to Mrs. Kowalski, no, I don't.
1001-2.
Can you just answer the question that's asked?
Yes.
Thank you.
1001-2326, please. Who's Elizabeth Sumner?
She was an ICU nurse.
Mm-hmm. Experienced nurse or not?
She was a charge nurse at the time, so yeah, I don't know her.
Yeah, you see her ranking it at 10 on the pain scale?
Yes.
And then you go down a little bit more, and there's another 10 on the next entry. One says, like, apparently she was asleep. But on the under over awake and alert, it says 10. See that? And then we go down to Elizabeth Sumner, a 10. Do you see that?
Yes.
Do you see under Kelly Thatcher, a 10? You see that?
Yes.
You see then under Kelly Thatcher, an 8.
Yes.
And I apologize. I said you were in the 10s too, but yours was a 7 and then a 6, right?
Yes.
And then a 7 and a 6, right?
Mm-hmm.
Okay. So apparently she got in more pain during the time because Sumner and Thatcher were on the 8th the next day, right?
Yes.
Okay. So would you agree with me that many people felt Maya came in with a 10 on a 1 to 10 scale in pain? One 001-2450. Maya was also, when she came in, inconsolable, was she not?
I wouldn't say she was. Maya was yelling.
Mm-hmm.
Yes.
Doesn't it say inconsolable?
Well, those are the options they give us.
I see. And then I believe you gave Maya, or excuse me, not you necessarily, but the care team there gave Maya a number of different medications, right?
Yeah.
And those medications included not only the ketamine, but you also gave her tramadol, is that right? And then, where's the meds page? I'm sorry.
Would also like to see documents for reference during testimony.
If I can find it, I'll show it. He'll find it. All right. In the interim, let's pull up 2045-024. Well, hold on from that. What actually happened was Maya received some medications, right? Then it tried to snake a nasogastric tube down her nose, right?
I don't recall that.
Yeah. And once you tried to snake a tube down her nose, she rebelled, right?
Objection to the extent counsel is testifying and not showing the witness the records.
I don't recall that.
You don't recall having to put somebody else having to help you hold her down while you snaked a tube down her nose? None of that comes back?
No, we do those a lot. I don't recall that. I don't.
And in fact, once people started to grab her and put something down her nose, she really went wild, didn't she?
I don't recall a feeding tube and putting a feeding tube in there.
She went wild because you were hurting her, correct?
I don't recall putting a feeding tube in Maya.
Okay, well. (1001-1056). No, that's not it. It's 1001-2722. I apologize.
I'll object that note has nothing to do with this witness.
Can you find that too? It's on the narrative on the top. So you don't remember now putting the tube down her nose. Did somebody else do that?
I don't know.
All right. What actually happened here was that Beata Kowalski challenged you, right?
Objection, argument.
Oh, sorry. We're back. Okay. Please take a look on your screen. Does it say nasogastric tube?
Yes.
Objection again. This document has nothing to do with this witness.
And her name on the bottom? Can we just go with legal objections?
Objection, foundation.
And what's the time?
That's her name right there. You can continue, Mr. Anderson.
Well, it says I reviewed it.
Okay, so you stepped out while they were putting the tube down her nose?
I don't recall doing that. I don't know where the documentation is, who put it in. I mean, if I put it in, possibly, but I'd have to see the documentation because this just says I electronically signed it.
Well, how'd your name get on there?
Because the order came through, but it might not have been done. If the order came through at somebody put the order in at 13:04, at 13:19, I saw the order and signed it, but that doesn't mean that the tube went in at that time. That means, okay, yeah, I see that there's an order. I don't know when the tube went in. I don't remember doing it. I put hundreds of tubes in, but I don't know if I did that or not. I know I signed it, but that's it.
Anything else? All right. So once you or someone, while you stepped out momentarily, put the tube down her nose or tried to, and held her down to do it, Maya went wild. So when you came back in, you saw her flailing and screaming, right?
Objection, argument.
Is that true or false?
Foundation.
I don't recall that.
Okay. And then after that, there were some cursing in the room, but it wasn't Maya, was it? It was other people in the room trying to hold her down, wasn't it?
I don't recall any of that.
And after that, were you the one that started kind of the narrative that Beata was nuts?
No.
Weren't you and Kathy Beatty telling everyone on that floor, watch out for this mom, watch out for the kid? They're a little crazy.
No.
Sorry, time. Your witness.
Nurse Clink, do you remember some questions about pain scores that were entered in the chart?
Yes.
If somebody puts a 10 down on a pain chart, is that something that the patient reports to the nurse?
No.
Okay. So.
Well, if you ask, it depends. If you ask the patient, you know, and you could ask the patient on a scale of 1 to 10, and then they can tell you that it's a 10. It depends if it's a small child, then you use different methods. Maya would know a scale of 1 to 10, so it's possible, most likely, that at her age she was asked on a scale of 1 to 10.
And I think you made it clear, but you don't have any recollection of placing a nasogastric tube down Maya Kowalski's nose?
No, I don't.
Thank you.
Anything further?
No, Your Honor.
Jury?
Judge, I gotta say, as I've watched all three witnesses today, and I watched the cross-examination specifically, I keep asking myself, why didn't the hospital settle? I mean, seriously, the cross-examinations have been very effective.
Yes.
There's information coming out that I think clearly supports the plaintiff's position. Again, you have to hear how they wrap it up in closing arguments, but I'm wondering.
Well, and I have to tell you, I see the opposite. I see some very strong points being made by the hospital, and the fact that there were actions by Beata that they saw, that they witnessed, that they're saying contributed to or caused Maya's behaviors. But I have to point this out. Perfect cross-examination to your point, because he wasn't concerned about the answer from the witness. He wanted to get out there. Isn't it true? You said, watch out what they did, and they're both crazy. He wanted the jury to hear those words.
Absolutely, and those are the types of things that I think are connecting this jury emotionally to the Kowalskis, and I'm not seeing anything that the hospital's doing with these witnesses to break that down.
That's fair.
That's my concern there. All right. We're going to take a quick break. We're going to have more from the Take Care of Maya trial when we come back. The jury questions for this witness should be interesting. Court TV is on your TV. Keep it here. Your front row seat to justice.
Detectives and investigators have recovered what's believed to be human remains at Chad Daybell's residence.
You have two children who have vanished, and their mother doesn't seem to care about where her missing children are.
If somebody 2 years ago said this is what's going to happen with Lori,
I mourn with all of you who mourn.
I would have never believed it.
Victim to Verdict with Ted Rollins. All new Sunday night, 8/7 Central, only on Court TV.
I desperately missed my family. I wasn't allowed to really have any contact with them. So in this document, I'm expressing how much I miss them. I was extremely depressed.
Welcome back. I'm Michael Ayala here with Judge Ashley Wilcott. We are following the Take Care of Maya civil trial out of Florida. The Kowalski family is suing Johns Hopkins All Children's Hospital, alleging false reporting of child abuse and other claims.
We just heard the cross and redirect of a former nurse at Johns Hopkins. Up next, juror questions. Always interesting to hear, Michael, what they might ask. But before we get back to testimony, let's bring in our guest for this hour, trial attorney Michael Jafer. Michael, thank you, of course, for being on with us. I want to ask you this, because here's what direct examination, in effect, did for the hospital. This witness testified the mother wanted the drug to sedate Maya. The mother woke her up to see if Maya was in pain. The mother was saying, she's in pain, and it's extreme pain. What you don't hear is Maya said she was in pain. Maya needed help because she was in pain. Is this enough to help the defense?
I absolutely think it is, because part of the testimony, they're doing a good job riling up the witnesses for the defense. But when that nurse was testifying, she said that one of the instances where the mom was telling me she's in pain, don't you see that she's in pain? Maya was asleep, her heart rate was very low, and she clearly was comfortable. And so we obviously know what the defense of the hospital is, which is we really had evidence to believe that the mom was making it up. Obviously, with hindsight, we know that's not the case. But at the time, without the benefit of hindsight, we know that that's their defense. So I do believe that this is enough to help the defense, because these jurors, they've almost all have treated at this hospital or have treated with a doctor who has rounded at that hospital. And they're aware that the family is asking for $200 million. So, you know, I see jurors a lot of times in these medical malpractice cases side with the hospital, but people who've had bad experiences with that hospital don't. But if there's a mother on that jury that has delivered at that hospital, it's going to be very, very difficult to convince that juror that this hospital should pay this family $200 million. I'm very unpopular with my friends for taking that position, and my job is to be on the side of plaintiffs in these medical malpractice cases. I've never represented a hospital. It's just not sticking for me from that angle. But they are taking some pretty good shots, on the plaintiffs are.
All right, and I have to agree with you. Well, let's see what the jurors think, because we can often get some insight into maybe what their perspective might be, or where they're coming from with their questions can help us understand. So let's get back into court for questions from the jury for this witness.
Nurse Clink, there's several questions from the jury. Have you ever worked with CRPS?
No.
Do you know how to work with CRPS patients?
I can't just answer that in a yes or no.
Well, explain what the best of your ability.
As a bedside nurse, as a bedside RN, our job is to follow the physician orders, and we treat as per order. So I don't go out of my scope of practice and do anything differently. I see what the vital signs are. I administer the medications. I take care of the things like her skin and things like that. I don't have a special, you treat them this way or that way. My job is to treat the patient as per physician orders.
Was Maya in any pain when she was cussing?
Maya did not say she was in pain. She would get very angry, she would get agitated, and I know kids can get that way if they're in pain. However, Maya was 10, and 10-year-olds would tell us if they're in pain or if something hurts them. Even if I ask Maya, or if it's like the pain scale, you can ask her, Maya, what's your 10, pain, are you in a pain of a 10? She would say, she can say I'm a 10 because she's 10 years old, but she never actually said, and I remember, she never said, this hurts, I'm hurting, this hurts me, my arm hurts, my leg hurts. She didn't say that. And that's what I thought was so unusual, because a 10-year-old would tell you, younger kids would say, my leg hurts, my head hurts. But Maya never told me I'm in pain.
Okay. Did Maya calm down after she got her meds?
Yes, Maya would calm down after she got her meds. I remember she would go up and down a lot. Those meds are heavy duty. Those meds were strong meds. Anybody who is on propofol or ketamine is going to be pretty much knocked out. So yeah, I mean, everybody, she would respond to pain meds.
Okay. As a nurse with 20 years experience, did you follow up with anyone if you had such a conviction that meant something, quote, my life is lies, end quote?
I think at that time I had moved from there. The physicians had known that because we had talked about that. Maya would shut down. I didn't have her again after that. It was hard to talk to Maya. Maya would kind of open up when she wanted to open up. I didn't ask her again. Things had started to become very difficult in the ICU. It became difficult. I didn't follow up, but I was hoping because she was still there and they knew that the rest of the team would take over, but I wasn't her bedside nurse. And the ICU started to escalate in tension and stress, and it was no way to go back and to do that. And I just couldn't.
Okay. The statement, my life is lies, did you report that to a doctor to follow up on, or did you follow up at a later time?
I discussed that with the doctors. I think things were starting to, like I said, things were starting to escalate. Tension was starting to go up. They knew, and my job as a nurse is to report. That's what RNs do. We don't step out of that scope, but I did report. They knew, and everybody, I think that they started to see, well, yeah, couldn't move her legs, but she was all over the bed. So I think the pieces were starting to come together. But my job was to tell them that she said that, and I put it in the chart to make sure that it's in writing, that the team knows. And they were notified, and then they take over from there. As a nurse, I mean, that's not out of my scope, and I have to stay in my scope of practice, and the doctors take over from there, from my reporting, and that's pretty much what nurses do. We are at the bedside the whole time, and we report changes because the doctors are in different places. We're assigned there, and we report things and then hand it off. But yeah, I mean, I wish she had finished that. that was shocking when she said that, and I wish I had the opportunity to do it, but there is nowhere for me to go from that, unfortunately.
Prior to working with Maya, how many children had you cared for with children with CRPS?
I don't know of any of them that had CRPS that would come into an ICU. I worked in ICUs, and so I don't know that they would probably be somewhere in outpatient but I worked with kids that had pain, and that was my job, is to treat pain. So they could have neuropathy from chemo, they can be in car accidents and have trauma. So my job was to deal with the pain and not the diagnosis. They can have whatever diagnosis, but I'm there to take care of them holistically with their pain, whether or not they have leukemia, a car accident, or CRPS. If they have pain, then I'm there to help them with that.
Okay. In response to the term inconsolable, when you say these are various options, do you have the option to free text?
Yes, I do have the option to free text. At the time, that was the first day that she came in, and there was so much going on in the beginning with the medications and the yelling, and the tension was rising. I didn't go back and free text. That would have been a good idea if I did. In hindsight, yeah, I should have free text, but those were the options, and there was just so much coming at me that day. I couldn't go back and start changing things because the ICUs are stressful. They're intense. That's why they're intensive care units. There's alarms. There's all kinds of things going off, and we're used to that. This was way above and beyond in the level of stress and the yelling. They were swearing. I should have free texted and said what I meant. I didn't, but there was just so much coming at me. It was hard to even stay afloat.
You know, Judge, I know you are concerned that this particular witness is talking too much. But I can tell you, it seems earnest to me that she wants to make sure she's telling a full and complete truth as she answers her questions, and I think it's endearing me to her and making me trust her.
Well, that's interesting, because I do feel like she goes on and on more than she should in response to the question, explain the answer, but then stop talking. But the jury asked what I wanted to know. Did Maya ever say she was in pain? Nope, she never said this hurts. That's something I noted.
One quick question before we go to break.
Yeah.
Is it possible that two things are true at the same time? That Beata may have been suffering from some sort of Munchausen's by proxy, but this little girl actually had CRPS?
Yes, because I haven't heard anything to suggest that she really doesn't have CRPS. Right. To your point, I think that, yes, that could happen. Right. All right, coming up next, more questions from the jury in the Take Care Maya trial. Stay with us. That's right on the other side of this break.
Tonight on Closing Arguments, 2 Indiana teenagers murdered, and now their alleged killer awaits trial. Our cameras are inside the courtroom for today's important status hearing in the Delphi murder case. What we learned today and what it all means for this high-profile case moving forward. Plus, previewing tomorrow's final pretrial hearing in the case against Charlie Adelson. What you need to know before this case gets underway.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott here with Michael Ayala, and we want to take you back into the Take Care of Maya trial. Now, in this case, we've been watching testimony from a former nurse who treated Maya in the hospital.
Yeah, her name is Johanna Clink, former RN. She treated her early on in her admission, just after her admission, the first few days there. She's been answering questions, I think, very honestly, but she has been rambling on. These are questions from the jury continuing, so let's get back into the court.
No.
How many residents were in the PICU on that night?
That night, I was working on the day shift. There would have been one resident that would have been assigned to her. I don't know which night they're referring to, but I worked on the day shift. And when there were the residents in the room when that incident happened where she cursed at Dr. Teppa, that's when there were multiple residents. There was probably 2 or 3 residents.
During your 12-hour shift, how much is rotation? How much is spent documenting?
We spend a lot of time documenting. The amount of documenting that we do on an admission, I mean, we are clicking through pages and pages and pages. It is a lot, and you just try to stay ahead of it. Meanwhile, you're getting orders that are coming in and they're changing. The orders are going up, they're going down, do this, you're doing that. So we spent in the beginning, there could be several, I would say 2 hours on an admission of just doing the whole admission profile. There's a lot of questions. Do you have a dog? Who lives with you? I mean, there's just so many, and I think that's where I got tripped up by not maybe going in and doing some more documentation, because I'm responsible for all just the basic stuff that comes in, and there's pages and pages and pages. And then I have to take care of the patient. So after the patient gets settled in, like that next night, that next day, it gets a little easier because all that intake stuff is very intensive to complete.
Have you ever had other kids in extreme pain use curse words?
Maybe it's not really, not that much, really. I think not that often. If they're in pain and I see that it's matching up with the monitor and I could see that there's pain issues, I could see their heart rate is up, their respiratory rate is up. Like I said, I'm very serious about a child's pain. It doesn't go to the point where somebody's swearing that they want pain meds, because I see they're in pain and I act on that. That was always one of my things is making sure that they're not in pain. I'm not going to wait and say, oh, I'm not going to give you the meds, wait until I'm done. I act on pain quickly, so it doesn't really happen, and it doesn't really escalate it to that point. And to swear, and it was more of, I wanted my effing sedation. That again is as a nurse, I'm looking at it like, she didn't say she was in pain, and she didn't look like so that's not, it doesn't typically happen that they swear when they're in pain. It could, but it doesn't typically happen. They get their pain meds when they say, I'm in pain.
In your experience, do medical staff have a general sensitivity to direct, opinionated parents?
I don't know what a direct sensitivity for direct opinionated parents, but I think all of us we have all kinds of parents that come in. Direct opinionated is completely fine. You are an advocate for your child, and I'm happy about that. I think a lot of us have that kind of personality where we have a strong personality. You have to be in an ICU, and I'm not sad over it. This was not that. This was way different. This was very demanding, and the curse words were kept coming. This was different. There's many parents. Parents are very protective of their children, and they advocate, and that's totally cool. That's great, and I'm there for that. This was not a direct opinionated. This was the ICU had become toxic, and that's a lot for an ICU nurse who had been there 16 years in ICUs. This was not like other ICU admissions. And So, no, we don't have a problem with people who are direct.
As a nurse, would you not want to chart disruptive behavior that a patient was displaying in her chart?
I would chart disruptive behavior. It's now, when we're looking back, yeah, I had Maya just in the first, all this stuff was in like the first, hours of admission, half hour. I had no preconceived notions. I didn't have any background to think, oh, well, wait a minute. There's patterns that's starting to form here. This was like completely a blank slate. I didn't know about any of this. Maybe after time would go on, I'd be like, I better put this down. When Maya said my life's a lie and I'm tired of all the lies, then I did start charting because I was like, whoa, there's something going on here that needs to be looked at. And I need to tell, and I did. And that is when it started. But in the beginning, I had no preconceived notions. I took everything at face value. And then things...
All right, still with us, trial attorney Michael Jafer. Michael, I got to ask you, we're looking at these questions, trying to figure out if we can discern anything as to how this jury might be thinking. I think we got one there with that last question. The question was, is there a sensitivity, or do hospital personnel have a sensitivity to direct, opinionated parents? And the reason why I say that's important is because it may be the way that juror sees Beata, which is positive. In the long run, she's a direct, opinionated parent, not one that's over the top. Now, this witness was sure to say there that this was much different than that, but what do you think about my assessment of that particular question and maybe showing the point of view of one of the jurors?
I didn't think about it until you parsed through the words direct opinion, because that was a question by a jury. So I do agree with you that the juror who asked that question had a sensitivity toward, well, I don't want to misspeak, believed that Beata was just an opinionated parent. And how do you deal with opinionated parents? Because you're dealing with minors, and obviously minors have a parent. And so how well do you deal with it? So I do agree with you. I think the response by this nurse, it helps the defense tremendously, because what she told them was, this was different. This was toxic. This was, we deal with them all. We deal with opinionated parents all the time. It's a good thing for us. Whether or not she believes it is a different story. But she said it and she seemed sincere. But this was different. The cussing, the swearing, and the juror who asked that, if they had a kid and they were in a pediatric, wing of a hospital, I'm sure they've seen other parents who were acting very outrageous, and they wish that they were not taking the attention away from the care of their own child. Again, I'm guessing here. We don't know who's on the jury, if any of them have kids, or if any of them have been to a pediatric hospital. But that's why this whole thing is up in the air. It really just comes down to the jurors and their own bias. I clearly have my own bias, right? And if I was on the jury, I would bring that bias in when I'm analyzing this case, and so are the jurors.
Yeah, and it could be biased. On one hand, it's life experience on the other that informs that, so that's perfectly reasonable for jurors. But I look at it like this. He very easily, or she very easily, could have asked the question, do they have a sensitivity to hysterical parents? Right. Or parents who are over the top? Like, it could have been a negative way to express that thought. So I think it makes a difference.
Yeah, I do think it makes a difference. The other thing, Michael, is you're right. I feel like these are non-responsive answers, in part because she goes on and on. But boy, by going on and putting out there, this was very different. The curse words, the aggressive, it was over the top. I agree with you. I think that was very important testimony for the defense.
No question.
All right. We need to take a break. Sorry about that. I might have stepped over Michael, but when we come back, we'll get you back into more of these jury questions.
Tonight on Closing Arguments, 2 Indiana teenagers murdered, and now their alleged killer awaits trial. Our cameras are inside the courtroom for today's important status hearing in the Delphi murder case. What we learned today and what it all means for this high-profile case moving forward. Plus, previewing tomorrow's final pretrial hearing in the case against Charlie Adelson. What you need to know before this case gets underway.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
All right, I want to get you back to the Take Care of Maya trial happening in Florida. Maya Kowalski and her family is suing Johns Hopkins All Children's Hospital in Florida for hundreds of millions for alleged malpractice.
And right now we're listening to jury questions for the former Johns Hopkins nurse. Let's get you back into court. You haven't missed any of those questions.
Things are not what they seem to be. Something's going on here and it needs to be looked at.
Next question. As a rule, if it is not documented, it did not happen, question mark.
So in nursing school, and we are drilled on that, and that is true. But that really speaks to, did you hang this antibiotic? You can't say, oh yeah, I hung this antibiotic, but I didn't chart it. It's for the patient stuff that you do. If you didn't, like I said, give this med, if you didn't do this bath, that kind of stuff is there. If you didn't do it, it's not done because you didn't chart it. This is not the same. This is what somebody else is. We are not expected, and it's 12 and a half hours and all of this stuff is going on. I can't chart all of that. So it's not an expectation, at least it wasn't then. And it probably isn't now because it's 12 and a half hours to document what other people are saying. That's different. It's not like hanging the med. Did you give them a bath? Well, if you didn't chart, you gave them a bath, then you didn't do it. Those are two different things. That's what I'm responsible as a nurse to perform those duties. That's what that is. So that part is true. Documenting what other people say, that's not in that realm of my responsibility. When Maya said my life is a lie, I'm tired of all the lies, that I thought I needed to document that. Because that was something above and beyond. But typically, no, we don't. And like with Bea, no, I wouldn't put that in the chart. That's not what I did.
We heard earlier that all children's hospital staff had nicknames for their patients. Can you tell me the nickname you had for the plaintiff?
I can say absolutely that's not true. I've not heard of nicknames for patients. I've not heard of that. I did not hear any nickname for Maya at all. I don't even know, I don't know if I've ever even heard that people have nicknames for patients. At least not, I never hear that in the ICU, and I haven't heard it on any of the ICUs where I work where people's like, oh, I call them this thing, I call them this. It's usually, somebody will say something, if there is, oh yeah, I have 554, meaning I have the kid in 554. But people don't, I've never heard people make up nicknames on patients.
Are you saying that either by mouth or by personal message group or by official medical records that for 3 months only a select few had knowledge of, quote, ketamine girl, end quote?
I don't know about what everybody else knew. I don't know. From hearing that, sometimes there's so many kids that come in, and if there's something that is very distinctive about a patient, somebody will refer and say something about, just so you can remember who this person is. I don't think it's done derogatory, but you have to have some way of remembering there's 29 bed ICU. Sometimes we flow to the other units. It's hard to remember, oh, this is John Smith. And of course, now we remember Maya, but that's only because of all of this that happened. Sometimes you have to come up with some way to say, yeah, this was, whatever, to designate who that patient was, but not to be derogatory. It's just, somebody's not going to remember, Susie Smith. It's hard. Some kids have, similar names. So sometimes, from hearing that, I think somebody may bring that up as a way to identify that person. but no, I don't think people don't have derogatory names for that, just so that people, I think that's what that is.
With all these, quote, team meetings, end quote.
All right, it's coming to the top of the hour. We're going to leave it right there for now. Coming up after the break, we're going to have a live report from Indiana with new reaction to Richard Allen's defense attorneys withdrawing from the case. What a shock. Stay with us. Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. Ahead this hour, a Florida jury returns a guilty verdict in the Bathtub murder trial. We will hear the emotional impact statements made by the victim's family.
Plus, the defense resumed its case in the Take Care of Maya's civil trial as witnesses explain how Maya was treated in her first few days at the hospital.
But first, a stunning turn of events in the Delphi murders case.
There are many dates in a lifetime that you're going to remember. The date your children are born, the date you're married, the date you buy a first house, the date Abby and Libby went missing. One of those dates was last Friday, October 28th, 2022. At that time, we had gathered evidence, and the judge did find probable cause for an arrest of Richard Allen. This investigation is far from complete.
As Mr. Allen is now without counsel, I've ordered him transported back to the Department of Correction. Obviously, without counsel, Mr. Allen's hearing cannot proceed.
What's your reaction to the fact that his counsel withdrew and he wasn't even in court today?
Very disappointed. It doesn't seem to be much of a surprise.
Now, today's hearing ground to an unexpected halt after Richard Allen's defense team asked the court to withdraw from the case. And the judge granted that motion. Allen never even made it into the courtroom after that turn of events.
We had hoped to hear more about some controversial issues in the case, including a bombshell leak of graphic crime scene photos, ritualistic killer claims, alleged law enforcement misconduct. The list goes on and on, all of which these issues are now all on hold. Richard Allen is charged with murdering Abigail Abby Williams, 13 years old, and Liberty Libby German, 14 years old, who disappeared while walking the Delphi Historic Trail on February 13th of 2017. The girls' bodies were found the very next day, less than half a mile from the High Bridge. Here with our debrief is Court TV crime and justice correspondent Matt Johnson, live outside that gorgeous courthouse in Fort Wayne, Indiana. Matt, talk to us more about what happened today in court.
Judge Ashley, Michael, you can still feel the ripple effect from that bombshell here in Indiana after Allen's attorneys quit before this previously unscheduled last-minute hearing even began. Happened earlier today. This hearing was set to take place at around 2 o'clock. There was a major delay, and then that happened. Today was the first time cameras were allowed in an Indiana courtroom concerning this case, and it was Court TV cameras in there set up ready to go. But Richard Allen didn't even step foot in the courtroom before the judge made that announcement. Podcasters, YouTubers, and just court watchers from the area drove miles and stood in long lines for hours to get a seat inside that courtroom. Libby and Abby's families were also in attendance in the first couple rows. 8 to 10 bailiffs lined the green marble walls, awaiting the transport and Allen to be brought into the courtroom. Then, after a long delay, Allen's wife, Kathy, was in tears and left the courtroom along with Allen's mother. They left the courthouse, and then Judge Fran Gull came in and made that shocking announcement of an unexpected turn of events. Here's reaction from a court watcher. Take a listen.
Very disappointed. However, just talking to some other attorneys and people local that have been following it very closely as well, it doesn't seem to be much of a surprise that they've recused themselves essentially from it. So very disappointed from my standpoint. However, it doesn't seem like it's that shocking to most at this point.
And this came as even a surprise, perhaps, to Allen's defense attorney at the center of a controversy, Andrew Baldwin, who retained his own counsel after leaked crime scene photos from his office, reportedly. His attorney filed paperwork saying that he remedied the case leak of court documents and the security breach at his office, saying, quote, he was snookered and abused by a friend. And we'll have more on his statement coming up next hour.
Matt Johnson, we were all dumbfounded by that today. I mean, it happened so quick. We were expecting something much more involved. So tell me, now that this is the situation, what's next?
So it really kind of delays the case, but Judge Fran Gull, who presides normally here in Allen County and makes the drive a couple hours away to the Delphi area where this crime took place, she says that a new attorney can be appointed fairly quickly. So the next hearing, which was the scheduled hearing that we were all expecting to take place on Halloween, it's still on the docket, and that could be the Franks hearing, which we're expecting to hear more about how defense counsel was trying to get the search warrant of Allen's home tossed out because they say that some law enforcement lied to the judge in order to get it, and that puts the whole case in jeopardy in terms of the gun that was taken into evidence from his house, because remember, there's that unspent round that was found between the two girls' body, connecting Allen to the charges and to this case. But again, all of this still up in the air, but here's what the judge said earlier today.
Mr. Allen's financial situation remains static, meaning he is to be entitled to appointed counsel. I will reach out to public defenders to make that appointment.
All eyes were on Libby and Abby's family, the grandparents from both sides. Kelsey German was also here in attendance. They were in the gallery. All eyes were on them when that announcement was made earlier today. And we just have to think about what they've been through all these years to try to fight for justice. They remain under a gag order, so they couldn't speak their mind after this bombshell in court today. But earlier in the day, the family of Libby's grandparents, they posted this statement: "May that which was done in darkness be brought to light, justice for Abby and Libby." So they left looking very unhappy today, as you would imagine, unable to speak to anybody. But again, all of everyone's thoughts and prayers are with them.
All right, Matt Johnson, thank you so much for that report. Truly appreciate it. And the only thing that we can probably say is that we know there'll be some delays. I mean, there has to be delays, no question about it. Let's bring in our guest. Joining us to discuss, trial attorney Lateef Gray is with us. Lateef, thank you so much for joining the judge and I on the show. I just got to get your reaction to what happened today. First of all, what do you think happened? My understanding is that these very same attorneys this morning filed a motion with the court seeking not to be taken off the case for various reasons, and yet this happens. What are your thoughts?
Well, apparently the judge reviewed the motions and whatever evidence there was related to this leak and whatever was going on, and decided that these attorneys could no longer be on the case for basically a conflict of interest. So I guess she understood what she was doing. She understood that this would delay the proceedings because a new attorney will have to be appointed, and it's going to take that attorney some time to, number one, get the file, and number two, to get up to speed. So the judge understood that by doing this, she was going to prolong the proceedings, but in order to protect Mr. Allen's rights as well as the victim's rights, she felt this was in the best interest of everybody.
So, you know, I really like this judge, and I thought she was very rational and realistic in saying, yes, this is going to cause delays because it's going to take a lot of time to get prepared on a case of this magnitude. But here's the big problem for me. Whenever you have an unexpected issue like this that causes a major disruption, attorney off the case, new attorney on the case, is it's not fair to anyone. It's not fair to the families who just posted about wanting justice. It is not fair to the wife who went out in tears. It's not fair to the defendant who once his day in court didn't even get into the courthouse. But at the end of the day, justice isn't always fair, and to get the right outcome, sometimes you have to go through bumps in the road, recognizing that it gets you to the right outcome eventually.
Right, and from the judge's perspective, her main objective is to ensure that the defendant's rights are respected. Because if they're not, and he appeals, then we could be right back here doing another trial. So her primary focus is on the defendant's rights, and the rights of the victims and the families are secondary. Although they're important, they're secondary, because if those rights are violated, there's no appellate right and there will be no retrial. So her job is to make sure that the defendant's rights are respected so that if he is convicted, it doesn't come back on appeal.
Exactly.
You know what, Lateef, when these attorneys first got on the case, they put out a scathing letter about the prosecution's case. And that prompted this judge to issue a gag order. Now, in the spring, there was some leak of evidence, and she admonished them, told them, okay, I'll give you a shot. Now, strike two. And I'm wondering, so let's be clear, the judge didn't remove them from this, they withdrew. And I want to ask you, do you think she basically told them, look, this is a third strike, you're out, you're going to be out of this case, I'm going to give you a way to leave gracefully, or I can do it in open court? Do you think a judge would have done that?
She may have, understanding that these are probably attorneys that she'll see again sometime in the future, and she's probably seen them before this case, and understanding that attorneys have reputations that we have to uphold as well. And so in order to not defame them and not, I guess, ruin their reputation, she may have done that. It's possible.
And I would shake my head yes, because I think it's absolutely possible. A lot of times we do, back in chambers, we talk to all the attorneys about everything to kind of figure out what direction it's going. And I think she could have been transparent about it at that opportunity. I don't know that, but that's certainly something I've been familiar with. Let me ask you about the actual evidence in this case. The leaked photos of the crime scene, now that we know they were leaked, they're out there. How does that affect the state's case, if it does at all?
Well, it may not affect the state's case, and it may make the state's case more empathetic to the potential jury pool if these pictures are so gruesome and so graphic that from a reasonable perspective of a juror, it looks bad. So it may help the state's case. It may hurt it, but I doubt it. I think it most likely will help the state's case.
Lateef, I don't know if you've ever been in the position where you had to take over a case in a similar situation where they've gotten through discovery and now you're sort of coming in because there's been an issue with the other attorney. But to the best of your ability, what is that new attorney facing? We've got a hearing coming up on the 31st. I promise you, there won't be a Franks hearing that day. There's going to be a lot more needed for preparation. But what is that attorney facing?
That attorney is facing having to get caught up on the case as quickly as possible. That attorney is facing possibly having to interview witnesses and conduct his own investigation. That attorney is facing rulings that the court has already made that still stand. That attorney is facing probably some angst and dislike from the victims' families. So that new attorney is facing a lot. He's facing the same things the previous attorney was facing and more, given that he is not as familiar with the case as the previous attorneys.
Lateef, you got the call. You're the one that's taken over this case. Are you excited or are you a little scared? Because this case has basically the country's eyes on it.
Yeah.
Well, from the attorneys are competitive. So from a competitive standpoint, I'm excited that I get to be on a challenging case. But I'm also scared, given that, this is a difficult case. The defendant is not that popular amongst the potential jury pool and amongst the people in the courtroom. So it's a little bit of both, a little bit of excitement that I've been appointed to such a high-profile case, as well as some fear that I don't want to mess the case up, and my client is not the most popular at this point. So it's a little bit of both.
And now cameras are allowed, so even if it had to be delayed before the hearing is shown, they're also going to be seen around the world. That adds to the pressure. I have to say this, all of those things that you've described that we as trial attorneys know how to do, hours and hours and hours and hours and hours of prep, Michael, to even get caught up.
Oh, the boxes, they're going to be, 10 rows, 6 feet high.
Yeah, and you have to go through all that and cipher through it.
Which is why I said no way on the 31st is anything really substantive going to happen.
I would agree with you there. All right, we need to take a break. Coming up next, we will dig into the charges that Allen is facing and take a closer look at the allegations made against investigators who served a search warrant at the defendant's home. That's next here on Court TV.
Plus, after being found guilty of murder, David Tronis will spend the rest of his life in prison for killing his wife. We're going to hear her son's tearful address to the court moments after the verdict was read. Keep it here on Court TV, your front row seat to justice.
Tonight on Closing Arguments, 2 Indiana teenagers murdered, and now their alleged killer awaits trial. Our cameras are inside the courtroom for today's important status hearing in the Delphi murder case. What we learned today and what it all means for this high-profile case moving forward. Plus, previewing tomorrow's final pretrial hearing in the case against Charlie Adelson. What you need to know before this case gets underway.
Closing arguments tonight at 8, 7 Central, only on Court TV.
Continuing now with our coverage of the Delphi murders. The suspect, Richard Allen, was supposed to be in court today to address a number of issues, but instead, the judge announced his attorneys had removed themselves from his case.
Now, the parties are set for a hearing on Halloween concerning possible misstatements used by police to get a search warrant for Allen's home. Now, Allen's public defenders filed what is known as a Frank's motion before stepping down. They argue evidence obtained from a search warrant should be inadmissible because a detective lied to obtain it.
The 136-page motion outlined 92 reasons the girls' murders could not have been committed by a single person and instead pointed to members of a white nationalist group known as Odonists.
And Court TV crime and justice correspondent Matt Johnson has a look at the accusations against Richard Allen.
Best friends 14-year-old Libby German and 13-year-old Abby Williams were dropped off for a walk at the Monon High Bridge Trail in Delphi, Indiana, and were never seen alive again.
When they got out of my car, I made sure they both had sweatshirts. I told them goodbye. I told Libby I loved her. They walked out, and that was the last time I saw them.
They never showed up to be picked up, and the next day, February 14, 2017, search volunteers found the girls' bodies in the woods. The mystery of the so-called Delphi murders was a big story across the country, and investigators revealed very few clues, including possible suspect sketches and parts of a recording found on Libby's cell phone. Nearly 6 years had passed with no real leads. Then, in October of 2022, a break in the case, an arrest.
Today is not a day to celebrate, but the arrest of Richard M. Allen of Delphi on 2 counts of murder is sure a major step in leading to the conclusion of this long-term and complex investigation.
Police revealed their suspect had been living in plain sight all along. Richard Allen was a local husband and father, working as a farm tech in the town's CVS.
Now we have a person charged with it, right? We have a face, we have a name.
What would you say to Libby after you guys finally got this guy behind bars?
Oh, I believe that she helped lead them. I believe that she was steering all along. And I believe she's up there quite excited.
According to the probable cause affidavit, Allen placed himself on the trail when interviewed by police in 2017 and admitted to seeing the girls there. Police say an unspent round found near the girls' bodies went through a gun that belonged to Allen. And a witness allegedly placed a man who looked like Allen walking near the trail wearing muddy and bloody clothes.
It's scary just knowing that he was so close, and we had no idea.
Richard Allen has pleaded not guilty and denies any involvement in the murders of Libby and Abby.
All right, still with us, trial attorney Lateef Gray. Lateef, let me just first start with a broad question, and that is when you have these hearings, these Frank hearings to not allow evidence in, how successful are defense attorneys in these? Because I feel like the ones I've seen that usually are not very successful.
I've seen them filed numerous times, seen maybe 1 or 2 granted, so the success rate is not that high. It usually has to be a situation where it's clear that the person who drafted the affidavit, which is usually a police officer, it has to be clear that they lied and made false statements under penalty of perjury. So the success rate is not high, and it's a difficult challenge because you pretty much have to prove that the officer lied and that at the time they wrote the declaration, they knew they were lying. which is a hard thing to do.
I was going to say it's a hard thing to do, and generally people want to believe law enforcement isn't going to openly lie like that. So I think it's an even higher burden.
Yeah, no question. And you know, these are de rigueur. You file these. You try to get rid of a search warrant, especially if that search warrant got something that's really good for the state's case. You do everything you can to kind of undercut it any way you can. Here's the problem with the claims being made, and you let me know what you think of them, Lateef. Basically, they're not so much claiming that they lied as much as they omitted information. So for instance, there were some other descriptions of different cars that they didn't include that they're saying could have affected a judge's decision. They're saying there were other descriptions of people that didn't match Richard Allen. They didn't include those in their application for this search warrant. Is that going to be enough?
It probably won't, because that sounds like an issue that should be left for the jury to decide, and that the defense attorney should bring up to the jury as a way to put an alternative theory of who did this in front of the jury. So I don't think it'll be successful, and a judge might rule it goes to the weight, not the admissibility, meaning you can argue it in front of the jury and let the jury decide whether they believe it or not. So I don't think it'll be successful.
But I also wonder, is missing information, omission versus lying, really not semantics? Because even if you don't lie, if you're leaving out half the story, that can mislead a judge. But look at this in the whole context. This case has been a mess, quite frankly, ever since it happened. There have been accusations of law enforcement not following up on all the leads, not doing everything they could and should. And I'm not saying there's merit to that, but there's a whole lot of discussion surrounding this case of a lot of things not being done correctly. How does that play in at all, or is that all noise that doesn't make its way into a court hearing?
Well, that has little to do with the Franks hearing, which is based on lies put into the affidavit in support of the search warrant. But these are issues more appropriately left for the jury, meaning as a defense attorney, you get the cops on the stand and you cross-examine them about, why didn't you do this? Why didn't you do that? And it goes to impeach the credibility of the law enforcement involved, but I don't think it's appropriate for a Franks hearing.
Yeah, I would have to agree. I look at it very similar to when you're trying to get an indictment. You know, you can indict a ham sandwich, they say, and the reason for that is you really only have to bring in evidence that goes in line with your theory of the case. You don't have to bring in all the other stuff. Same thing with a search warrant. If I have enough, if judge thinks that what I have on this particular person is enough to get a search warrant, then I get the search warrant. It doesn't matter if there's 4 other people who I'm looking at as well. I may have to get search warrants for them. So that's the way I look at it. I mean, do you agree, Lateef?
I do, but from a law enforcement perspective, it kind of makes them look bad if they didn't uncover every stone or turn over every stone. And in a case like this, where it took them 5 years to arrest this individual, you probably, just to be safe and understanding that you're going to have to testify about certain things, you probably want to do your due diligence and follow all these leads if possible.
And they did follow the leads, Judge, and I think the purpose, and a lot of the purpose of this defense, once they got the case from the very beginning, was to counter all the negative information about their client. So even in filing something like this and making this information public, I think it has the desired effect, even though they may not expect to win.
Right, and you know, it's that presumption of innocence that everyone always says about defendants. But with this particular case, to your point, Michael, I feel like the publicity has really hung him out to dry. Without regard to that presumption of innocence. And so how do you get a jury? Even if you change venues, how do you get a jury anywhere in that area that has not heard of this case, Lateef?
It's going to be difficult, because one of the questions we ask jurors is, do you know anything about the case? Have you read anything about the case? Have you heard anything about the case? And given that this is a high-profile case that's been covered by numerous media outlets, including Court TV, it's going to be difficult to get a jury of 12 or 14 with the alternates that haven't heard something about this case. So finding a jury with no preconceived notions and hasn't heard anything about this case might be next to impossible.
Yeah, and you can see on these pictures, my name is on there. Why? Because I actually went to Delphi. I went to the crime scene. And you can see nobody's in these pictures. Everybody in the community that we spoke to said this used to be a bustling, busy trail that people were on all during the year. And you can see here, nobody was there. It was so eerie and sad and creepy that justice is definitely deserved in this case, like all of them.
Yeah, and one hopes that if and when this case is over, things return to normal.
Yeah.
People feel comfortable going back out there, you know, but some really crazy allegations in this one. So we'll see it all sort of shake out in the wash at trial, hopefully. All right, still ahead in the Take Care of Maya civil trial, witness after witness testified about things they noticed about Maya during their examinations and about some unusual requests from Mom. That's next here on Court TV.
Detectives and investigators have recovered what's believed to be human remains at Chad Daybell's residence.
You have two children who have vanished, and their mother doesn't seem to care about where her missing children are.
If somebody 2 years ago said this is what's going to happen with Lauren,
I mourn with all of you who mourn.
I would have never believed it.
Victim to Verdict with Ted Rollins. All new Sunday night, 8/7 Central, only on Court TV.
I'm Matt Johnson in Fort Wayne, Indiana, covering the Delphi murders case. This is Court TV, your front row seat to justice.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott.
And I'm Michael Ayala. We want to turn now to the Take Care of Maya civil trial going on in Florida. The defense resumed its case, calling more healthcare workers to the stand.
They all testified about their conversations with Beata Kowalski and Maya's care and about some of the things they noticed when they were treating Maya.
I did meet with the father. One of the pieces that was signed out to me by Dr. Teppa was the family's interest in potentially being transferred to Nemours Children's Hospital. And they had reached out to their ICU physicians over at Nemours about a transfer. And so I spoke to father and I told him that I would reach out to them. And I did speak to an ICU physician at Nemours who had reviewed the information that they had been provided over the weekend. They had discussed it with their pain team. And at that point in time, they did not feel like she was a candidate to be transferred to their hospital. Mrs. Kowalski was concerned that the information was not appropriately provided to Nemours and that there was potentially, you know, facts of Maya's history that were not provided. And so she really wanted to arrange a conversation with them so that she could tell Maya's story. Soon after our conversation with the physicians at Nemours and my understanding that we were going to hope to get her there as an outpatient, the mom told me that she really wasn't interested and wanted an intrathecal pump and wanted to explore other places to have this, and I believe it was Cleveland Clinic that she thought that they could potentially be transferred to get an intrathecal pump.
She just kept saying it's hurting. She would call out like any other kid to her mother, "Mom, please, I'm hurting." The things that developmentally, you know, kind of stuck to me and still after all these years, and she was saying things like, I need my anesthesia medication, I need my medications. She would tell the nurses, give me my medicine. She would say, I need you to push the medicine. I mean, those are things that I have heard between us, you know, in the medical field, and that kind of stuck in my head as a 10-year-old, you know, kind of requesting very specific things. She would say the names of the medications that also kind of stuck in my head a little bit. What I was seeing, Maya saying it was hurting. And it was mostly related to, like I said, the nurses trying to put the stickers on the chest so we can get the telemetry, which is that monitoring, and also evaluate the respiratory rate and things like that. Mom was on and off, kind of like on the bed with her or off, talking to me. And it really struck me that the stimulus to the pain, where she would like, I was trying to kind of gather what was making her hurt. you know, it deferred to whoever was doing it. So it was the nurse putting the stickers. It was like, oh, that hurts so much. Please don't do that. But you know, mom would hug her and, you know, rub her back, but that didn't seem to be hurting.
Mrs. Kowalski would not let me take a blood pressure on Maya. She said it was going to cause her pain, and I said, well, we need to have a blood pressure done on her. And she said, well, if she has blood pressure taken, that she needs to be pre-medicated for the blood pressure. Mrs. Kowalski told me that Maya can't walk because of her CRPS, and I took her at her word for that. I mean, that was okay. I understood she had some issues, medical issues in the past and now. Except then I saw Maya was on her knees on the bed, and she was moving around on the bed on her knees. And I was like, Maya, you're moving on the bed. You know, and in the hospital, it's hard to move on your knees on a bed, on any bed. It takes a lot of strength to do that on a bed. But this was an ICU bed that had an air mattress. So with these air mattresses, you sink into the bed. And to be able to move like that while you're sinking, I thought was a little bit suspect. Like, how did you do that when you can't walk?
All right, still with us, child attorney Lateef Gray. Lateef, I got to ask you, because after hearing the testimony I've heard today and throughout the trial, here's where I'm at with this case. I think Beata was a handful, clearly. There may have even been something wrong psychologically with her. But I also think that there was something very wrong with Maya. I think she had CRPS. So both of those things can be true. What does that mean for a juror in this case?
It means that the jury's going to have a difficult decision. I mean, this seems like a tough case to begin with. And the fact that there have been 8 amendments to the complaint lead me to believe that they're having a hard time linking causes of action to particular entities, meaning they're having a hard time figuring out who to sue. So it's a tough case. Both things could be true, meaning the child could have been sick and the mother could have had some issues. And so it's going to be tough linking what the hospital did to the mother's actions thereafter, where she, I think, committed suicide. So it's going to be a tough case. The hospital staff has mandatory reporting requirements, which mean if they think that the child is being abused, they have to report it to the authorities. And so I know the mom and the family are claiming that certain things happened as a result of the reporting, but the hospital had a mandatory duty to notify the authorities about possible abuse.
And here to me is what is indicative of this being a tough, complicated case. And I'm hoping we have a full screen with this. If not, we can talk through it. But the different counts, some of the counts, the defense asked that the judge get rid of, right? And in doing that, she denied some of them she reserved judgment. And here's an example of one that she granted the defense's motion. So negligent infliction of emotional distress for Jack, which is the brother of Maya. The judge said no.
Jack is the dad.
Jack is the dad. Apologies. Yes, Kyle is the brother.
Yes.
Jack is the dad. She said that's one that she granted the defense's motion, so that one's out of the picture. As we go through each of these things, that means she didn't see any evidence supporting that, so that one was kicked out. How much does that affect? Because it's complicated for this jury.
Well, it could affect the jury, but when you file a lawsuit, you want all the charges to stick, but if at some point after the jury's heard all the evidence, some of the charges or causes of action stick, then you're in a pretty good position. So the fact that she kicked out a count related to the dad or the brother, I don't think it really affects the jury, because if she deems that there is enough evidence to continue with the trial on certain charges, then the jury will get to deliberate and decide whether the hospital is liable for those causes of action.
Lateef, I agree 100%. And I really think what this case comes down to is emotional connections. And I think It was established during the plaintiff's case, and especially when Maya was on the stand, and we heard stories about Maya from other family members and other people in the know on what happened to her, that an emotional connection was established. And I get that feeling because some of the questions that I'm hearing from these jurors, they've put themselves in the seats of this family. That's what I think they are. And I have seen nothing in the defense's case to sort of break that aspect of the case down. They're doing a great job on the facts, but the emotional side, they haven't really addressed that as much.
And they may not be able to address the emotional side, because at the end of the day, we have a family that went to the hospital, and they're claiming that as a result of things that happened at the hospital, another family member took her own life. So they may not be able to attack the emotional connection, and maybe that's why they're focusing strictly on the facts and the law, and saying that even though the facts may be true, the law is not on the plaintiff's side. So you never know. They may not be able to deal with the emotional attachment.
Yep, you may be right. All right, stay with us, Lateef. Up next, jurors reach a verdict in the Bathtub murder trial in Florida.
State of Florida versus David Tronis, case number 2020 CF 12472AL, the Circuit Court of the 9th Judicial Circuit in Fort Orange County, Florida. Verdict reads, we, the jury, find the defendant guilty of first-degree murder as charged in the indictment. So it says we all, dated at Orlando County, Orange County, Florida, on the 18th day of October 2023, signed by the foreperson.
But before the verdict was read, the victim's family gave tearful impact statements. Hear what they said after the break.
A reminder that Court TV is always on 24/7 on our YouTube channel. If you missed an amazing courtroom moment, or you want to catch an episode of our compelling original programming, you will find it there, and much, much more.
Tonight on Closing Arguments, 2 Indiana teenagers murdered, and now their alleged killer awaits trial. Our cameras are inside the courtroom for today's important status hearing in the Delphi murder case. What we learned today and what it all means for this high-profile case moving forward. Plus, previewing tomorrow's final pretrial hearing in the case against Charlie Adelson. What you need to know before this case gets underway.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
After nearly 6 hours of deliberations, the jury returned a guilty verdict in the Bathtub murder trial in Florida. David Tronis was accused of killing his wife, Shanti, during a tense home renovation.
Before sentencing, Shanti's son and ex-husband gave emotional impact statements about their loss.
Verdict reads, we, the jury, find the defendant guilty of first-degree murder as charged in the indictment. So it says we all, dated at Orlando County, Orange County, Florida, on the 18th day of October 2023, signed by the foreperson.
My mom was the best person I ever knew. It's like a hole in my heart that I can't fill or fix. She didn't die peacefully. She did not deserve anything that happened to her that night. My family and I have been waiting for about 5 years for justice. I miss her so much. I would have never thought the day before was the last time I would see my mother alive. I miss the times where we would go to Universal, or just the simple times, like walking the dogs or going to the park. She was the best mom I could ever ask for. That's it.
It is not without its curveballs and heartaches. And when we divorced, as difficult as it was, one thing we never fought or wavered on was raising Jackson the best we could. He got his brains, his compassion, and his outlook on life from his mother. And her and I moved forward and continued raising a wonderful son. When this parasite came into our lives, he took something from us, and most importantly from Jackson. And what he took is not replaceable. It is something that I struggle with every day. He lost a good parent. It is still unfathomable to me what he did to her and what he put Jackson through. As I've struggled to understand, to this day, The only word I come back to is evil. Only evil would do what he did to her and Jackson when he had the choice not to do what he did. After today, this parasite's name will never be spoken again. Anyone who knew him will forget him. He will never be remembered or thought of after today. No one will ever call or visit him where he's going. He will be forgotten, and he will not even be a footnote in this world.
Court will adjudicate you guilty, will sentence you to life imprisonment. With credit, 1877 days. Impose all the statutory required court cost, fees, cost of prosecution.
After the sentencing, Tronis was immediately taken into custody and fingerprinted.
After court, the victim's son and ex-husband reacted to the verdict and the sentencing, saying it was a long time coming.
It's like a weight lifted up. It's like a weight that's been lifted off of our shoulders. It's like 5 years of struggle and pain lifted off of our shoulders, and it feels good inside that he's finally where he is, and now that we can move on knowing that he's where he's supposed to be, where he's meant to be.
Not only did I ever think we would get here, it just seemed so distant that I thought it would never happen, and now that it's happened, I guess exhilaration and just a little bit of peace. Something we haven't had since 2018.
All right, still with us, trial attorney Lateef Gray. And Lateef, the pain is palpable as you listen to those victim impact statements, and again, those statements after everything was over. But I would be remiss if I didn't mention that the family at the very beginning of this is Florida, this was a death penalty case. The family were the ones that wanted the death penalty off the table. Prosecutors followed suit, took it off the table, so he's going to prison for the rest of his life.
Yeah, and maybe, you know, the family is just against the death penalty. There are a lot of folks out there who are against the death penalty. And in reality, if he gets life in prison, he's never going anywhere. He'll never see the streets again. So he's going to die in prison one way or another. So I can understand the family's perspective. There's no need for the death penalty if he's convicted. Well, he'll never see the light of day, and he'll die in prison. So it's essentially the same effect.
And Lateef, he was convicted of the first-degree murder. We know that the jury received the 2 lesser counts, second-degree murder, heat of passion, but those were not the decision of the jury. And I get it. I see how it's first-degree. I think in part because of the things that he did afterwards to cover up and going for a walk with the dogs, cleaning up the yard, and then the story he came up with for what happened that didn't match the forensic evidence that was introduced by the state. So at the end of the day, I didn't feel like this was a case that it was surprising that we ended up with a conviction for first-degree murder. But what do you think?
Well, from what I understand about the evidence, yeah, it's not surprising. I mean, he gave a statement which appears to be concocted and not based on fact, and he behaved in a way that some would say shows a consciousness of guilt. So, yeah, it's not surprising at all. Yeah, I'm not surprised.
You know, it got me thinking when the prosecutor gave their closing arguments, they basically said that when he strangled her, it takes time to strangle someone. And in that time, that's when it was okay for the jury to determine that's where the premeditation came from. And I got to thinking, can you actually strangle someone without premeditating that murder? I mean, what are your thoughts on that? You're a defense attorney, you represent different folks. If you've got a strangulation death, it takes time to complete that act. During that act, you're actually, I guess, forming the intention to kill.
Yeah, it would be hard to argue against first-degree murder when you have a strangulation. And also, a strangulation is an up-close and personal crime. It's more personal than, say, driving by and shooting somebody. You know, you have to put your actual hands on the person and squeeze them and squeeze them and squeeze them until they no longer have any life. So it would be hard from a defense attorney's perspective to argue against first-degree murder when you have someone who's been strangled in a situation like we have here.
These victim impact statements were really hard to watch. This poor kid, I mean, we were able to show his face because he's given interviews and such. So let me be clear that it was allowable for us to do that. But to hear, I have a hole in my heart, I miss her so much, she's the best mom I could ever hope for. Do these make a difference in the judge's sentencing? Do you think potentially, had she not heard from the ex-husband and the son, that she may not have said life?
No, she probably would have said life, but they do make an impact because they're emotional, like you said, they're passionate, and they're conducted in a way that they let the judge know, the court know, that not only was the victim affected, which she's no longer, but also her family and loved ones were also affected. And as a result of that negative effect, you should impose the maximum sentence allowable, Judge, and that's what she did.
Yeah. Are you surprised by it, Michael, quickly? I know we have to go to break.
No, I'm not at all. I mean, this was one of those cases where I think it was clearly set up by the idea that, you know, he killed this woman and that he made, you know, some sort of attempt to get away with it, and it just didn't work.
And to cover it up, I agree. Thank you so much, Lateef Gray, as always, for being with us. We appreciate you. And Michael, what's coming up next on your show?
All right, there's much more ahead in our next hour, folks. The day after Joran Vandersloot confessed to killing Alabama teen Natalie Holloway, we hear from him about what happened that night. Also, an attorney claims that suspect Rex Uerman has been linked to at least 2 other victims in the Long Island serial killings case, and a stunner in the Delphi murders case as the defendant's attorneys step down. We'll have a live report, so keep it here on Court TV, your front row seat to justice.